So what I will do now is I will ask the owners, Mr. Pitlarge, to open the case.
Thank you, Mr. Chairman. I don't know whether it's just me, but sometimes I think with these LMA arbitrations, it feels like you're performing to an audience. But this has been a hotly contested arbitration. The only common ground is expert evidence and perhaps the choice of the venue for the arbitration, for which we thank the Charterers Advocate. I act on behalf of the owners of the Blue Chip Naples, Blue Chip. Their personification is Mr. Trefilis, sitting to my right. Mr. Trefilis is a well-known industry figure with interests as diverse as shipping, quantum physics, and investment banking. The Charterers are deep pocket, as you have said, represented by Mr. Lauro. The claim concerns three main items, which you've identified. Time lost due to the vessel's underperformance caused by hull fouling. Principally, that time loss has occurred following a lengthy delay at Paranagua. That lost time equates to $250,000 in lost hire and fuel consumption. Additionally, after discharge on the Paranagua voyage, there was an agreement, we say, for the vessel to deviate to Singapore. There was a short deviation and hull cleaning, which cost the owners $30,000. So the amount in dispute is $280,000. The amount which I am claiming as deducted hire is $250,000. In the way of these things, I actually have to meet the Charterers case and anticipate that, and I will do so in my submissions, but I stress to you that it is not my case. My case is that I'm entitled to the hire, which is my cardinal right as an owner. I accept that I have to make the case for the deviation time and the hull fouling expenses at Singapore. So if we look very briefly at the facts, gentlemen, it's a one-year charter party on conventional New York produce 1946 terms. I will take you to the central clauses about speed and consumption warranties, but I think it's also important to note that this really is pretty much a bog standard New York produce form. In particular, it has its standard off-hire clause, clause 15, and there is no additional deviation wording that I've been able to see in the copy which the parties have been working on. The case, as you'll see, turns largely on the wording dealing with what I accept as a continuing warranty, and I accept I have to deal with that. As will become apparent from these submissions, I would have had considerably greater ease had it not been what for the Charterers is the fortuity of the High Court's recent decision in the Coral Seas. Anyway, the specific terms which you have unusually in an arbitration put on the slide concern the vessel's description and its standard with 14.5 knots speed in ballast, 14 laden. The central provision on which my friend Mr. Lauro relies upon is the speed warranty, the continuing warranty, and there you have it throughout the currency of this charter. Owners warrant that vessel capable, it's a warranty of capability, of maintaining the speed and shall maintain on all speed passages the relevant speed. So, the facts will show that there was a short ballast voyage on delivery. Thereafter, on the first laden voyage, there was, as the expert evidence has shown, a falling off of speed from the warranted laden speed of 14 knots to 13.1. The vessel was then sent to Paranagua. She was delayed for 40 days. What exactly was going on at Paranagua remains obscure, and it's something to be explored with Mr. Rondinella. The owners, through Mr. Trefilis, and he will give evidence on this, were trying to find the reasons for the delay there, but those remain obscure. What is clear is that as a direct result of that 40-day delay at Paranagua, the vessel suffered bad hull fouling, which caused the speed to fall off from, depending where you start, 14 or 13.1 to 11.8. So the central feature of this case is the delay caused by the 40-day unexplained delay at Paranagua, leading to substantial hull fouling. And the evidence. The evidence is largely uncontroversial, as you have acknowledged, sir. The expert evidence attests to the fact that the reason for at least a diminution in speed from 13.1 to 11.8 was the delay at Paranagua. There is no clear expert evidence on the initial shortfall, but I invite you to find that whatever that might be, the vessel delivered complying with all of her warranties, and there has been no breach, nor has there been one advanced by the charterers for any breach of the condition on delivery terms. This is a case about the breach of the speed warranty. Mr. Trofilis will give evidence on a number of factors, in particular, and this is material to the factual background to the case, that following discharge at China, and conscious of the potential knock-on effects of the hull fouling, the parties reached an agreement for the vessel to deviate slightly to Singapore and there to have the hull cleaned. It is also Mr. Trofilis' evidence that the charterers recognized, and one of the reasons they agreed to that bargain was that the whole problem was caused by the stay at Paranagua, and they were not going to pursue any claims in respect of the delays which form the 250,000. What I submit has happened is that having access to excellent legal advice, they've been advised of the recent court decision in the Coral Seas, and what you see before you is nothing short of an opportunistic scam to deprive the owner of his hire. This raises then, if we come to the law, three principal issues. The first is, and let me just make the point, that this is a deduction case. It's not for me to convince you that I'm right, it's for Mr. Lauro to convince you that he is within the off-hire provisions, or that there has been a breach and a causative breach of a term which entitles him to damages. Leaving aside, I accept the indemnity or the payment of the 30,000. And that raises, as it commonly does, three issues. The first is off-hire. I would accept that if Mr. Lauro could bring the charterers within the off-hire clause, I would be in difficulties, but I don't think he can. It raises the question of the implied indemnity in two respects. If the hull fouling has been caused by the orders to go to Paranagua and wait there for whatever reason, then I'm entitled to an implied indemnity for the consequence of causing that loss. And that would meet a breach of the speed warranty because there would be security of action. Finally, we have the speed warranty itself, and the central question there is, should it apply in a way in which the owner has no opportunity to avoid the aspect which causes the warranty to be breached, and that which has caused the breach is entirely due to the charterer's operation of the vessel. I say I win on each point, and while there are a few hurdles to overcome and some obscurity, the commercial and compelling good sense of making sure that a well-maintained, fully operative ship should be able to earn its hire. Let's deal with off-hire very quickly first. As I say, the burden is on the charterer to bring himself within the off-hire clause. That is uncontroversial. He will say, I am sure, that he is entitled to do that where there is a defect in hull. It is well-established authority on the basis of the RIN that a hull fouling is not a defect. Now, I accept that was moderated in the Joanna, but that degree of relaxing of the rigor of the rule in the RIN only applies if you can show that the hull fouling existed on delivery. These should be, sir, uncontroversial submissions. Where the hull fouling has occurred in the course of the charter, the standard clause 15 term, I submit, will not assist a charterer. That leaves me with the Singapore point. Well, I would say that as we're performing the charter service, we still don't fall within clause 15 for the same reasons. It was found in the Kitzer that the deviation to do the hull cleaning there was off-hire, but that was on the basis of a specific deviation clause, and there is none, as I've indicated in my opening. The implied indemnity, if we may. I will come back to the Coral Seas and the speed warranty, but the implied indemnity was conceded in the Coral Seas, and I do not concede it here. Much has been written on the extent to which the implied indemnity is available. My friend, Mr. Lauro, will doubtless rely on the Kitzer. The Kitzer is a narrow case. It's very familiar to you in particular, sir. But the Kitzer, if you'll recall, was a vessel which was delayed at Visac for only 22 days. It was a case in which Mr. Justice Akins accepted the factual findings of the tribunal, and that was the delay of 22 days at Visac was something that was foreseeable, a risk accepted by the owners. So we have a day in our case of 40 days. It was not foreseeable, and Mr. Trefillis' evidence goes to that. So I think you can distinguish the Kitzer on the basis of the stay. If you do so, then I should succeed because I can meet the speed warranty case with the implied indemnity. If you do not accept it, you have to accept that there's something in it, because regrettably, in the High Court's approach in the Coral Seas, wrongly in my view, imported some of the concepts of the implied indemnity. There it was an allocation of risk, as the implied indemnity is, but there has to be some separation, I would say. Clause 29. Clause 29, I accept, is a continuing promise by Mr. Trefillis' company that the vessel should perform 14 knots in laden conditions, and she has not done so. It has been accepted and been in editions of time charters, which I think you would all agree is an authoritative text on this area, that where the owners give a continuing undertaking as to performance of the ship, and that ship has in fact underperformed, it is a defence for the owners to prove that the underperformance resulted from their compliance with the charterer's orders. Now that is a contract point, not an indemnity point. It's well established, it's there in Wilford. Now, the attraction of that approach, I would submit, is that it aligns the contractual position with that you see in the off-hire clause in the RIN and the overall scheme of a time charter where you have to be duly diligent and maintain your vessel as best you can, but there's no absolute rule against the owners for defects that might arise. This would all be fine were it not for the Coral Seas, which my friend will rely on, and which was handed down by the court in the course of this summer. The Coral Seas said that the passage I've read to you from Wilford was too wide, or time charters, and quite how wide it should be is unclear from the judgment, and as you respected commercial arbitrators, I would ask you to treat even that approach with some skepticism. The court was nevertheless unattracted by the owner's position and held that the absolute warranty, which is no different in material terms, should bind the owners, and that after a stay of some 26 days at Guaiba Island, they should be responsible for the lost time as a breach of the speed warranty in the terms you have before you in this case. The court's approach was that given an owner can have an implied indemnity, it should look to that, and if it cannot look to that, then it is clear that the allocation of risk is against the owner delays in tropical waters while in coral seas, clearly loading her cargo, are foreseeable risks undertaken by the owner. Further, that given there was a reference in the speed warranty to fair weather, as there commonly is, the parties could have addressed the whole issue of hull fouling. And indeed, as we all know, there are many hull fouling clauses, the basic point being, if you wanted to legislate for hull fouling, you could have done so. In answer to this, the owners say, you should not confuse the implied indemnity with the contract terms. They are two rivers that run pretty much in parallel courses, but they don't always go to the same place. The indemnity was disavowed in the Coral Seas. I do not disavow it in this case. Even if you're against me on the implied indemnity, I don't think you can use the lack of availability of it as somehow infecting the allocation of risk in this case. The alternative wording point, I think, as a matter of principle, is unsound. There are plenty of dicta from some of the leading recent judges, Lord Hoffman in the Achilleus, there's a passage of Lord Neuberger, all to the effect that you should look at the words before you, and it's not a sound way of construing contracts to say that a different point should have made in different or clearer terms. As Lord Neuberger said, that is a game which all parties can normally play on issues of interpretation. So, you should have said it point is not a good one. Further, we have the Hague-Visby rules, which excuses the owners from fault. Those are incorporated into the Charter. It follows, gentlemen, that the vessel remained on hire throughout all of her ocean voyages. Further, the owners are entitled to an implied indemnity. The Kitzer should be distinguished, and you should make a finding of fact on that point. And if you make a finding of fact on that point, you have nothing to fear from applications for leave to appeal and such like when you make what I submit is the right and commercial decision. You should not seek to rewrite the parties' bargains on the basis of what they've left out. The parties have not agreed that the owner should take the risk for an extensive delay of 40 days at any port. That is not clear from the terms. On the contract, the agreement which was reached between Mr. Trifilis and Mr. Rondinella, that effectively precludes the right to rely on Clause 29. Owners conducted themselves on the basis of that conversation, and the rights, even for the Paranagua voyage, were waived. In any event, either as a matter of implied indemnity, see above, or by way of a variation to the time charter, the owners are entitled to be indemnified for the time and expense of going to Singapore.